All right, moving on to Form 201, the exclusive buyer agency agreement. You know, as part of the antitrust settlement, there was a lot of changes in the settlement that were mandated to be in buyer agency agreements going forward. Some jurisdictions are going to have a real heavy lift with that because they don't have buyer agency at all, which we do here. So, um, that was beneficial. But on top of that, the form was already in substantial compliance with the settlement. Even as it was, there were a few things we had to do in response to the settlement, but all in all, the form was something that really did a good job of making sure that the buyer agent and the buyer are making the contract with each other, and that contract is something that, while it could potentially be satisfied or paid by the listing agent or the seller with cooperative compensation, it didn't necessarily have to be. There are some change to that and the way the standard language operates, which are real important. And we'll go through that in a minute. But let's start on page 1 here in Form 201 and look at some of the changes on the first page. So right here, you can see right at the very beginning, there was a really good paragraph that already existed here. It's just that it was kind of block text and might not be something that people really noticed. So what we did is broke it into separate paragraphs, and then also, as I mentioned in a previous video, that the buyer may or may not be working with the relocation company, making sure you guys know that and understand that, so you know it from the beginning, and it's not some kind of surprise later on in the transaction. The other things that are in here, 1, 2, and 3, are really important. And so we wanted to make sure that this was clear to the buyer from the beginning and not some block text that they would skip right over. Although, while I'm here, I will note that if you go up here, there's some really interesting language up here in this block text that maybe we'll do something with later, maybe not. I don't know. That'll be up to the forms committee. But if you look right here at this language, one of the things that I usually talk about whenever agents want to talk to me about it is this section right here. And that's this part. And the interesting thing, oh, hold on. Yeah, sorry. The interesting thing about this language to me, well, I'm not sure if I can make that box go away. In any event, you can see what's there. The interesting thing about this language to me is that a lot of agents who call the NC Realtors legal hotline do not understand that the agreement, the agency agreement, is between the client and the firm. And the language that I highlighted right there says that the individual agent who signs the agreement on behalf of the firm will be primarily responsible. However, it is understood and agreed other agents in the firm may be assigned to fulfill such duties if deemed appropriate by the firm. And what that means is if you've got a situation, especially if you're in a BIC, can come in extremely handy all the time. And this is also in Form 101, the exclusive right to sell listing agreement. But if you've got a client and an agent who they're just loggerheads, they can't really work it out. They apparently got along well enough to get the agency agreement signed, but it's just not working out. This language here can be very helpful to make sure that you don't have to let that client go if you really don't want to. They have a contract with you. They have made an agreement, with you, and you've made an investment based on that agreement. And so, and especially in the case of buyers, you might be showing them homes for who knows how long before they find a home that they like, right? So this is helpful language to have right at the beginning of the agency agreement so that you know that if you need options to be able to sign someone else in there, if you have the ability to do so, that's something that you can do. It's right there, right at the very beginning. So I figure while I'm here, while it's not a technical change to the form this cycle, sometimes it's a good thing to know. These things are also a good thing to know, that the buyer's not a party to any other agency agreement, that they've got a copy of the working real estate agent's disclosure, and that the buyer has disclosed to the firm information about properties that buyer's already visited. Now, granted, there may not be as much of a procuring cause issue going forward, but understand that arbitration is still there. So depending on how listing firms may or may not offer cooperative compensation in whatever way they choose to do so outside the MLS, that may be something that you'll still be able to pursue. Procuring cause may well still be a thing. So just understand that could be out there. Be cognizant of it, and just be aware of what a listing firm may or may not be offering, or an unrepresented seller if you're in that context. Okay. In any event, it's good to know whether they've already been shown a house or not, especially if it's a builder. That situation comes up all the time where, builders will, if they see someone and they don't have an agent with them already, then then they will keep a list, and then you may have difficulty getting cooperative compensation from the builder if the buyer's already been shown the house by someone else. All right, moving on down. Before we get into all this green down here, okay, I want to stay right up here, okay? Don't skip too far with me, because paragraph 4B right here, where it says buyer agrees that firm's fee for services hereunder shall be the amount of blank. This has been a section that buyer agents have not been very good about filling out, okay? And come in a couple weeks, if you fill this out, something like per MLS or some other thing that doesn't mean anything or actually specify any compensation, you're going to be pretty disappointed by the time you get to the closing table. So especially if you're a BIC and you have agents under you, doing buyer agency, you really need to make sure that they understand that this blank cannot be ignored any longer. It really needs to be filled out specifically. Besides the antitrust settlement requiring it, it's been required under North Carolina license law for certainly as long as I've been aware of it. So in order to be in compliance with license law, you had to fill out this section anyway. You've got to have an agreement with your buyer for how much you are going to be paid. And that is going to be extremely important. It is something that you're going to want to make a very calculated business decision about. Because once you sign a buyer agency agreement, going forward, and as we're going to talk about a little bit more as we talk about some of the other forms changes, is the buyer doesn't have to agree to change that compensation once they've agreed to it. So whatever you put in here, make sure that is something that you have taken the time and consideration to value your services and what you want to be paid. Granted, yes, it's going to be market driven to a certain extent. Sure, that is to be expected. A lot of things in this industry are market driven, but at the same time, the value of services is quantified however you want to quantify it, right? That's the whole point of running your own business. If you are an independent contractor with your firm, you are in a sense running your own business in many respects within limits of your independent contractor agreement and things of that nature, within MLS rules, code of ethics. There are certain things that you have to abide by, but otherwise, a lot of you appreciate the freedom that comes along with being able to run your practice, how you deem fit under the auspices of your firm, right? So going forward, this cannot be ignored like it has in the past. And the changes, interestingly, especially in red, the do not insert NA0, you can see that this language was already here. It's just being emphasized. Specific dollar amount, things of that nature, just moving some of these things around to make them a little bit better. That is something that is normal, has been there the entire time. It's just being emphasized to make sure that you guys are able to do what you need to do.